Okay, so today we're going to look at the operation of the doctrine of precedent. This is an area of the study design that students tend to find very challenging, and it's an area that tends to separate the top students on the final exam. So it's really important that you have a really good understanding of this area of the study design. It covers a whole range of things. It covers stare decisis, ratio decidendi, obiter dictum, binding precedents and persuasive precedents, and it looks at ways judges can avoid precedent, including reversing, overruling, distinguishing, and disapproving. It's important that you understand all of these elements of the doctrine of precedent. We're going to go through each one today. Firstly, stare decisis is essentially the principle that underpins the doctrine of precedent. Literally, it means to stand by what has been decided. That when a decision is reached by a higher court, the reason for that decision is binding on all lower courts in the hierarchy. This provides predictability and consistency as cases with similar facts should be decided similarly. The ratio decidendi is the reason for the decision. It's the binding part of the judgment. It's the thing that creates the precedent. The material facts are those facts that are just vital to the reason for the decision. If there's more than one judge in a case, then the majority decision will create the precedent. A precedent is binding if it comes from the same hierarchy of courts and from a higher court in that hierarchy. So we can say that courts must follow precedents from higher courts in similar fact situations if that higher court is in the same hierarchy. A persuasive precedent is not a binding precedent, so courts don't have to follow it. They can come from decisions of courts on the same level in the hierarchy, from decisions of lower courts in the hierarchy, from decisions of courts in a different hierarchy, either from a different state, maybe the federal hierarchy, or even a court from another country, such as England or the US. It can also come from obiter dicta. As we said, the persuasive precedents are not binding, but they may be influential. Obiter dictum is literally things said by the way. It's a statement made by the judge. It's the opinion of the judge. It's not part of the ratio decidendi. It doesn't create a binding precedent, but it can act as a persuasive precedent. It can be influential in future cases. So there are ways that judges can avoid following precedents. They can reverse a precedent, they can overrule, they can distinguish, and they can disapprove. A really good acronym is RODD, R-O-D-D, that you can use to remember the 4 ways that judges can treat previous precedent. Firstly, reversing a precedent occurs when a case is appealed to a higher court. When this occurs, the higher court can overrule the precedent created by the lower court's decision. That reverses the earlier decision and creates a new precedent which will then apply for future cases in similar fact situations. Overruling a precedent occurs in a different case to the one that established the precedent. When a different case is heard in a higher court, then that higher court is not bound by the previous precedent created in a lower court. Therefore, if they disagree with the precedent, the judge can overrule the decision of the lower court. That creates a new ratio decidendi, a new binding precedent, which will apply for future cases. For both reversing and overruling a precedent, the new precedent cancels out the old precedent, and the old precedent no longer applies, and the new precedent will be the one that goes into effect. The difference is that reversing is the same case on appeal. Overruling is 2 completely separate cases. One established the precedent previously, and then a new case is heard in a higher court, and there the judge can overrule the previous decision. Distinguishing a previous precedent occurs when the facts of the current case are different, significantly different from the case that established the precedent. And if the material facts are significantly different, then the judge can decide that the court is not bound by the previous decision. The previous precedent doesn't apply and they're free to rule however they see fit. Disapproving a precedent can occur in three ways, depending on at what level the court the case is heard, depending on relative to the case that set the precedent. So if a case is heard in a higher court than the case that set the precedent, if it's heard in a lower court than the case that set the precedent, or if it's heard at the same level, then judges can disapprove the precedent in slightly different ways. Firstly, if a case is heard in a higher court than the one that set the precedent, then clearly the higher court is not bound by the previous precedent. However, they may tend to follow the previous decision for the sake of consistency and perhaps for justice, and instead express disapproval in Obiter. So give their opinion that they do not agree with the precedent, but they're going to follow it either for consistency or perhaps for the sake of justice. What that can do is influence Parliament to change the law. So they may say, I'm going to follow this decision, however, I think that Parliament should step in and change the law. And there's a really good example of that in the Trigwell case. If a case is heard in a lower court to the one that set the precedent, then clearly the lower court is bound by that previous precedent, so therefore it must follow the decision. However, if the judge does disagree with the precedent, if they think it's wrong, if they feel that society has changed, they can express their disapproval in Obiter and say that they feel that this precedent should no longer apply. And that can be influential in later cases, or could be influential for Parliament to change the law. Finally, if a precedent is heard at the same level as the case that set the precedent, then courts will usually follow that precedent for the sake of consistency, however they're not bound by it. So they don't have to follow the precedent. They can create a different decision, and both precedents then remain in force until a case is heard in a higher court. Now, often that case would then get appealed straight away to a higher court, and the higher court would rule which precedent remains in force. But until they do that, both precedents remain in effect because neither one is from a higher court, so neither one can take precedent over the other. And that is the doctrine of precedent.